General Lynch, I especially appreciate in your response to Judge Carter's question how important it is that every law enforcement officer out there in America know that the Department of Justice has their back. That is a message I hope you will continue to speak out loudly and clearly and repeatedly to make sure that all those local law enforcement officers know how dedicated you are and your department is to supporting them and helping them. Last August, our neighborhood deputy, Darren Goforth, was murdered in my neighborhood, and it was a catastrophic event. And all of us, I know, on this committee and across the country, are very concerned. We want every law enforcement officer in the country to know that the members of Congress, and particularly the Department of Justice, that we have their back and we support them. Recognize as a part of that relationship that you have with local law enforcement, one of the most critical parts of that successful relationship is the sharing of information, that local and state and federal law enforcement officers have to know, have to have a complete and open relationship where they share every bit of information possible about criminal defendants, and a source of great concern to the country. And I know from our conversations before the hearing began, a concern that you have as well, and I'm delighted we're headed the same direction, is with sanctuary city policies, that where a state or local jurisdiction refuses to share information with the federal, whether it be Homeland Security, Judge Carter, or with the Department of Justice, because that information sharing is so critical. And the policies that a lot of these cities and counties and states have, where they will refuse to honor a detainer, to hand over a criminal defendant in their custody to federal authorities to be deported, is just unacceptable and terribly dangerous. Of course, it's standard procedure if individuals in the Williamson County Jail, if they're in the Pulaski County Jail, Mr. Chairman, and they have before they're released from that county jail, it's just long-standing common sense that the Pulaski County Sheriff is going to check with state authorities, with federal authorities, is there an outstanding warrant? And that individual, when he served his time in the county jail, will not be released onto the streets of Pulaski County. If there's a warrant in Michigan, they're going to call Michigan and say, do you want this guy? And Michigan come pick him up. And that has been the standard policy of every law enforcement agency in the history of this country. Until you get to these sanctuary cities, where they will not release these individuals if they've got an illegal alien in their custody who is a criminal warrant for their arrest. These communities have policies that they will not release them to federal authorities for deportation. And this is just absolutely unacceptable. It's outrageous and has resulted in the murder of untold thousands of individuals. And the one that I know that hangs in everyone's mind with great concern is the young lady who was shot and murdered in San Francisco, Kate Steinle, who died in her father's arms as a result of she was shot and murdered by a 7-time convicted felon, a 5-time deportee who was released onto the streets of San Francisco due to their utterly unacceptable and illegal sanctuary policy. And that refusal to share information, that refusal to cooperate with federal law enforcement authorities is just absolutely unacceptable. And as we talked about earlier, as the new chairman, the rule is going to be in this subcommittee, if you expect to receive federal money, comply with federal law. And I want to thank you, Attorney General Lynch, for your timely response to a letter that I sent you earlier this year on sanctuary cities, where in your response to my letter, and am I expressing the concern that I just laid out here, you said in part that where the Department of Justice receives a credible allegation that an entity, state or local, is receiving funds under a department grant or reimbursement program, has, after they have assured the department that they're in compliance with applicable federal laws, where that entity is, where you have credible evidence that they violated a specific applicable federal law, the department can potentially seek criminal or civil enforcement options against that entity. As we had discussed, the Title 8, Section 1373 of the U.S. Code specifically prohibits states or localities that have policies that prohibit the sharing of information with ICE about the immigration status of their prisoners. That law says very clearly that local jurisdictions cannot interfere in any way with the sharing of information with federal authorities. I wanted to ask, and if I could you assure the committee that the Department of Justice will review grantees with such policies to ensure that they're in compliance with all applicable federal laws?
Well, certainly that is a part of our grant review process. And as was also conveyed in the letter, I do want to reiterate the fact that one of the things that we are hopeful will be as effective also and more immediately effective is our policy whereby the Bureau of Prisons is, instead of deferring to the state or local entity detainer and turning an individual, a deportable individual, over to them, that instead Immigration Customs Enforcement, or ICE, will instead have the ability to step in and exercise their detainer first. We have in the past deferred because, again, we work with our state and local colleagues, and we want to make sure that they can, in fact, adjudicate their cases as well. But particularly where we are dealing with a jurisdiction that essentially is not prone to honoring the ICE detainers, and those vary across the country. They just vary over time and place. Our policy is going to be that ICE will instead have the first detainer, and that individual will go into ICE custody and deportation. Now, this may have the effect that there may be local cases that may not be able to be prosecuted because, again, the person will be taken into ICE custody and then deported. And if a jurisdiction has a concern over that, we will talk to them, but we would have to have assurances that ICE would also then be able to get the individual back at the end of an adjudication, so that the deportation process could go underway. So we are trying to be respectful of our state and local colleagues' desires and goals to prosecute cases, but also deal with this issue as well.
I genuinely appreciate that, and I think as an example of the cooperative relationship that this committee has had with the Department of Justice and with you as the new Attorney General, I want to express my sincere gratitude to you for this new policy that you've adopted. Yes, Mr. Chairman.
With the chair, you.
Yes.
I'm not clear. Will the department seek to cease any grants going to a particular so-called sanctuary city if they violate your terms? Will you seek to stop a grant program?
Well, where, again, if the grant is tied to the applicable law, again, it has to be a connection between the issue and the grant. For example, a grant for human trafficking would be different from a grant for community policing. But certainly as part of the audit process, as part of the Inspector General review, and as part of the overall grant management review, which the Department's Civil and Criminal Division can also take under investigation, if we receive a credible allegation that a grantee has violated a specific applicable federal process in general, but we also have the Office of Inspector General who can step in and do a specific investigation of a specific jurisdiction or municipality. And we also have our civil and criminal divisions, depending upon how the allegation arises.
Is this a new policy?
Well, I think it is in response to the concerns that have been expressed and and in result of the discussions that we have had with the chairman here as well as other members. But as I indicated, we feel that a way to deal with this issue immediately is to make sure that individuals who are being released from the Bureau of Prisons, rather than be released into state custody, would go directly into immigration custody and be dealt with for deportation there. Because part of frankly, a large part of the problem has been that as part of our collaborative working relationship with our state and local partners, as Mr. Chairman, you indicated, if there's a detainer on an individual coming out of federal prison, certainly when I was a young prosecutor, individual will be released from federal custody but have to go into New York State custody to either finish a sentence or to be prosecuted. And then at that point, at the end of the state case, deportation would be an option. Where a city is not necessarily inclined to work with the Department of Homeland Security, and frankly, as a general matter, we will instead use the immigration detainer first. And as I indicated, where jurisdictions indicate this was likely to be a problem, we will talk with them and we will work with them. But it is an area of great concern for us. It's particularly an area of concern for us because there is unfortunately case law that exists that only in one circuit, but there is case law with a particular holding that in certain circumstances, cities' compliance with the requirement that they provide us information may be voluntary. We're also actively litigating the matter in 2 other jurisdictions. And so this matter may be unsettled for some time in the courts. So we feel that a way to deal with this issue immediately and directly is to have the policy change, as well as to have the review of the grant program that we've been discussing.
It's really a great example, Mr. Chairman, of the cooperative relationship that this committee has had with the Department of Justice. I'm very grateful to you. She's announced today a new policy that first of all, the Department of Bureau of Prisons will first check to see if there's if a criminal alien in the custody of the federal prisons has a deportation order, and where that individual may also, as in the case of this guy that murdered Kate Steinle, where San Francisco has a policy they're not going to honor the federal detainer in response to the concerns of that this subcommittee, Mr. Chairman, has addressed to the Department of Justice. You've changed the policy at the Bureau of Prisons, which we deeply appreciate, that you will not release that individual to San Francisco. You're going to hand him over to ICE, Chairman Carter, so he can be deported. We thank you for that change in the policy. That's very important. And then secondly, we've also learned today, Mr. Chairman, and we very much appreciate that, the department is moving towards, because this will be litigated forever, and we can't wait on that. Our lives of countless Americans depend on quick and decisive action. And in response to the concerns I've expressed earlier this year, you responded immediately and in a very favorable way, which I really appreciate. They're moving right away to go look carefully, and we will provide you with that list of those jurisdictions that do have policies where they will not share information with federal authorities. They've actually got an explicit policy on the book. We're not sharing information. We will not hand over these individuals to ICE for deportation. We can provide you with that list, and you've just indicated that you're going to begin an audit process to ensure, to encourage them, because we want them to change the policy. We're not looking to cut them off from federal money. We want to give them a chance to change their policy, correct? And that's the goal. Change the policy so you hand these individuals over to federal authorities for deportation.
Mr. Chairman, if I could
yes, please
suggest something. This is encouraging to hear this. But I believe that old saying of trusting and verifying.
Yeah, Ronald Reagan and.
Yeah, I wonder if you could give us a report on this after a period of time here, say 4 months, to give us a report on how many of these instances you have actually had success with, so that we have some way to gauge
exactly
how things are going, and maybe make mid-course corrections as we go. This is significant, very important matter for a lot of us, and I'd like to know that it's working. Is that agreeable?
Well, certainly I think that we're all moving to an evidence-based model in a host of things, and certainly we're happy to work with you and your staff to provide you the information, both with regard to the new BOP policy, which I think would be instructive.
Yes.
Also, and also any instances, again, where these allegations occur. As you know, however, once the matter goes into investigation, if we refer it to the Inspector General, for example, we wouldn't have the information about the investigation readily available at that point. But certainly, if these situations do come up, I think we can work with the committee to find a way to keep you informed.
Let's do a quarterly report.
Let's do that
for a while to see how things are going. So we would expect that you would give us a report on how things are going, as much detail as you can give us at the end of the first quarter.
I think that's a good idea. Would that be agreeable?
Thank you.